Hi, my name is Danielle Dietrich, and today I'm going to talk to you about veteran-owned small business and service-disabled federal veteran-owned small business. It's a mouthful. Status and how to appeal if you have been denied or decertified from one of these statuses. VOSB, VOSB, veteran-owned small business, and SDVOSB is service disabled veteran owned small business. We love our acronyms in the certification world. If you're a veteran and you own a small business, you're likely aware of these contracting opportunities. And small business all depends on the SBA classification for your industry code through the NAICS codes. So what is qualified as small is usually depends on your receipts, and for some categories, it is number of employees. If you're a veteran-owned business, you're likely aware of these. They help you compete for federal sole source and set-aside contracts within the federal government and certain agencies. And these can be very lucrative certifications to have, and these set-asides can be really great. But what comes with them is also a lot of challenges by competitors who don't have those certifications, or maybe you're applying and you're having some issues and you're denied certification. So, I want to talk to you about your rights today in both of those circumstances because they're very similar. So, a denial is when you apply for either VOSB or SDVOSB certification and you get denied. And a decertification is if you have one of these certifications and they seek to revoke your certification, whether that is on the agency's own or after a complaint from a competitor or something of the like. So there is a right to appeal, but I wanted to make this video because it's a very short time frame to appeal. This is probably the shortest I've seen for a certification. You only have 10 days from the date of the denial or notice of decertification from when you receive those to file an appeal. So 10 days is very, very short. Now, to file an appeal, you do not need to have an attorney. However, it is very helpful to have an attorney. Attorneys are trained advocates. Knowledgeable attorneys who know about the regulations, know what the regulations require, and they know how to apply the facts of your business and the circumstances there of your ownership and the kind of work you do, how to apply that to the regulations to make an argument for why you should be certified or why you should remain certified. So, having an attorney to advocate for you is really something that is worth a small investment because these contracting opportunities can be so valuable to your business. It is worth spending the small amount of money, and it shouldn't cost a ton to help get this appeal filed for you. But you can do it by yourself. I will say, there's a saying for attorneys, only a fool has himself for a client. So, you take some risk if you do it yourself. But I want to tell you a little bit about how the appeal process works so that when you're considering that, you know what you're up against. So there's no exact format required for the appeal, but it does have to contain certain information. Of course, you need a copy of the denial or decertification. You have to submit and say what date you received it. And then you have to explain why the denial or decertification is in error. And this is the advocacy portion. This is really where you need someone that can lay out the facts and apply them to the regulations and make a clear showing as to why your business needs to be certified. You can also include any other information you think the judge should know. This is not an invitation to air all of your grievances, whether about the program, whether about a competitor, like none of that is relevant. Only what should be mentioned should be things that come into play with your certification. And then, of course, you or your attorney's name, telephone number, and email address. That seems simple, and your mailing address. It seems simple, but sometimes people leave that out. And my theory for these things is always make it as easy as possible for the decision maker. Give them all the information that they need and to make it very easy for them so they don't have to do a lot of work. So, very easy. Give them all your contact information, but a lot of people forget that. Don't make them have to go look it up. And then once you have this appeal ready, you have to do a few things for it. You have to serve the entire petition and its attachments, if any, upon the director of the Office of Government Contracting and SBA counsel. That's served via email. you have to enclose a certification that you this, and there's a form available on the SBA's website for that. And then you also have to file a copy with the Office of Hearings and Appeals of the SBA. That's also done via email. Now, if you don't follow even one of these steps, your appeal may get rejected. And so once you file the appeal, what happens is that the administrative law judge who's going to make the decision gets a copy of the entire file related to your client certification, to your certification. And the office that made the decision, it has to respond within 15 days after you serve your appeal. So you served your appeal in 15 days, they need to respond as to why no, the decertification or denial was indeed correct. Now, generally, you won't get another chance to respond to whatever the office submitted in response to your appeal. So you won't get a chance to reply, a serve reply, anything like that. So that's why you have to state everything you want to state in your appeal. You can't hold things back because you're not going to have an opportunity unless there's something unique and the ALJ directs you to file a response. But that's only going to be directed to a certain point or points that were made by the government office. Well, once the ALJ has all that information, they make a decision. They look at everything in the case file and that you submitted, and if you want to submit other information that's not already in the case file, you have to make a good cause showing as to why it should be included because, hey, if this was so important, why wasn't it already in the file? So that is another area of advocacy that you will have to be aware of. And then they make the decision. The Office of Hearings and Appeals, ALJ, makes the decision and it's final. However, you can request reconsideration, either you or the government office can request reconsideration by filing and serving a petition for reconsideration with the Office of Hearings and Appeals and serving it all. And that all has to be done within 20 days after the written decision is issued. And in that petition for reconsideration, you must show that there was an error of fact or an error of law made that was material to the decision. And the ALJ can actually do a reconsideration on their own if, later on they will remember that, like, oh, wait, this wasn't right. There was an error. I don't think that happens too often, but it is possible. So that is just a general overview of the appeals process. Again, highly recommend you have an attorney assist you with the advocacy portion of this. If that is something that you need help with, please feel free to reach out to me and I can assist you. And we can talk about engaging me to assist you to do that. So thank you for watching. Look forward to seeing you in another video.